conferences. We've got some great information about updates on everybody's favorite compliance topic, the TCPA and more. We're going to spend about 50 minutes together today, ending with about 10 minutes of questions. We'll have the slides available after the webinar for folks to download. Eric, thanks for joining us today.
Absolutely. A pleasure, as always.
So we try to put together webinars on pretty much a as-needed basis, and lately there's been a lot of confusion around the TCPA with lots of cases, a little bit of change at the FCC leadership in regards to the TCPA. And so we'll have available the webinar today afterwards, so if folks can catch up if they're just getting on, and towards the end with the questions if they want to review those. Our company, Contact Center Compliance, is a leader in the compliance space. We've scrubbed over 30 billion phone numbers in 12 years with no violations or payouts to professional litigators. And we've come up with a couple new solutions to keep up with some of the cases we're going to talk today, including VoIP scrubbing. We actually have a solution for litigator scrubbing, which is very interesting. And it's been very successful at helping people identify, especially the serial plaintiffs that are floating amongst us. So hopefully we don't have any on the call today, but we do have some great slides, like I said, and I've had a chance to preview them, and I think there's some really good information and hopefully some positive updates for folks out there. We're also going to take a couple surveys and just get an idea of how folks are dealing with some of the issues and how much the litigators have been making the rounds, as they say. Let's jump over into the content. And again, really excited to hear Eric Allen give us an update and lay out kind of how we got here. So here's a little bit of a preview of the agenda, and I'm going to hand it over to Eric, who's going to get us kicked off today. And like I said, we should be able to have some time for some questions at the end. You can submit those via the GoToWebinar tool on the right, and that will give us a chance to tabulate them and as we go along, clarify anything people that are missing. Thank you again.
Awesome. Thanks, Ryan, and thanks for everyone for joining. I want to say we had just shy of 300 participants, so great showing. We're gonna focus on practical solutions today. I've gone in and taken out a lot of the legal citations and cut and pastes of the statutes and some of the case law. There's a few in there I can't get away with without, but for the most part I want to keep this simple and move quickly and talk about how in reality you deal with these new TCPA rules, how you either obtain proper written consent to call cell phones on a dialer or find other exemptions around those rules. I'm going to talk about some new risks like VoIP and professional litigators. Quick reminder about state and federal do not call rules, and then finally some information about the evil stepchild of telemarketing law, state licensing, meaning a part of the law that is often overlooked and ignored. And as Ryan mentioned, you can have the PowerPoint afterwards, so you don't have to take notes, but I may say things that aren't on the slide, so you may want to anyway. And then that'll be available, and also we'll take questions at the end, and you can email Ryan or I with additional questions later as well. So I'm Eric Allen. I'm a telemarketing attorney. I practice with my brother and wife out of Salt Lake City. We have a practice where we represent primarily call centers, meaning we advise call centers and defend them in compliance and litigation matters. We focus more heavily on the compliance side, but we also defend cases, class actions, and state cases. So practical solutions, quick recap on the TCPA, consent, VoIP, litigators, some D&C stuff, and then finally state licensing. Real quick, who is watching you? We're going to talk today primarily about the FCC, the Federal Communications Commission. The FCC, their big law is the TCPA, the Telephone Consumer Protection Act. So our National Congress passed the TCPA, but the FCC was authorized by Congress to interpret it and promulgate, meaning author rules regulations that flesh out and expand and define and clarify the actual TCPA statute. When I say the TCPA, I mean both the actual statute and all of the regulations and commentary the FCC has made about it. But don't forget, there are other agencies and groups who are also watching you. The Federal Trade Commission, or FTC, of course, the relatively new CFPB, Consumer Financial Protection Bureau. The USAG's office gets involved, in particular when there's a significant consumer fraud component in telemarketing cases. You also have 50 state attorneys general or division or local divisions of consumer protection, and they share data now. For a number of years now, the FTC has maintained this Consumer Sentinel system, which is a database where state AGs, FTC, FCC, and other local law enforcement agencies, and even some agencies in other countries now upload their raw complaint data. And that data can be queried by any of the participating regulatory agencies. Even the BBB, kind of the neighborhood watch of consumer protection, not government, but they observe and report. Even the BBB gets to upload its complaint data into the Sentinel system. The BBB and non-government agencies, they don't get to query it or search the system like the FTC could or a state AG could, for example, but that complaint data is in there. So a regulator who receives a complaint about company A can go in and search the company name or a phone number or other information associated with that complaint and pull every other consumer complaint received by any of these agencies that contains that that item, that phone number, address, business name, etc. Let's start out by talking about the new TCPA rules, in particular the wireless and dialer rules. We'll spend most of our time today on this. I assume most of the people on this call are somewhat familiar with the rules, but we'll quickly review them for those who are just getting up to speed. These new rules, most of them were made effective on October the 16th, 2013, so about a year and a half ago. What new rules will we talk about? Well, under the amended TCPA, the changes that went into effect in October 2013, we are now required to have prior express written consent for auto-dialed telemarketing calls to cell phones. So that would include things like predictive calls, pre-recorded, etc. Also, you need prior express written consent for pre-recorded telemarketing calls to landlines. So the rule is a little, it treats cell phones differently. They have extra protection. There are new rules and disclosures that are required for obtaining proper consent to auto-dial a cell phone. Also, there is a new or clarified opt-out rule for pre-recorded messages. That rule requires you to use an IVR or key press opt-out function, and also to affirmatively disclose in your message, your recording, a toll-free number that they can use to call back and opt out. The call abandonment rules changed also on October the 16th, 2013. The FCC's rule, or the TCPA, is now in harmony with the FCC's rule. Did I mix that up? The FCC is now in harmony with the FTC and the FTC's TSR, telemarketing sales rule. So abandonment rates, these are for predictive campaigns where you're on a predictive dialer that abandons a certain number of calls when the recipient says hello and you don't have a live agent to connect them to. That's an abandoned call. And you're not allowed to abandon more than 3% of all dialed calls as measured on a successive 30-day basis per individual calling campaign, and that's what was changed. This is measured on a successive 30-day basis per individual campaign. The new rules also got rid of EBR for auto dialers. EBR is still an exemption from the do not call rules, meaning if you're trying to call numbers on a do not call list, you still get a break if you have a relationship with that person. But EBR no longer gets you around the robocall rules. You can't just robocall your existing customer base anymore. That may get you around D&C, but it does not get you around these technology rules, these dialer rules. You need consent now. Wireless identification. Why identify and scrub wireless numbers? Well, unless you have proper written consent, then in general you cannot auto-dial cell phones, and this consent is somewhat hard to obtain, as we're going to discuss today. There are also, of course, significant fines and penalties. The TCPA has this very scary private right of action, allowing the consumer to sue you directly. A private action means they don't just, consumer isn't stuck with complaining to government and then waiting for government to take action against you. They can walk into their local courthouse or go find a local litigator to sue you, including in a class action, saying, Your Honor, we want to represent not only our client who received an illegal telephone call, but we want to subpoena all their call records, and we want to represent everyone who received an illegal telemarketing call from this company. How do you scrub wireless numbers? Well, you hire Ryan, of course, but more specifically, there are two wireless lists that you need to compare your calling lists with. First, the carrier file that contains, this is a little inaccurate, but sometimes it's called the wireless block file or cell phone prefix list. They're batches of numbers initially assigned to cell phones. The second list is the ported number list. That's a list of landlines that have been ported to cell phones, landlines which became cell phones. And remember, there's this limited 15-day safe harbor for ported numbers, meaning if you're doing a good job scrubbing against these wireless lists, and again, this all assumes you don't have consent. If you have the right consent or another exemption, then you don't need to remove wireless numbers. But assuming you don't have the right consent or other exemption, then you need to identify and scrub. But let's say that you scrub your list on day 1, and you call the consumer on day 2, and guess what? Earlier that morning, they had their number ported from a landline to a cell. You thought you were calling a landline, so you were using your predictive dialer without consent, but it was a cell phone at the time of the call. Well, there's this limited safe harbor, which in theory allows you to have a defense by proving that you scrubbed against that ported list within the previous 15 days. There's somewhat of a debate among the very few lawyers that do telemarketing law as to whether that safe harbor still applies post the October 13 rule change, but I think most people think that it does, and we've seen it used as a defense, and everybody's acting like it applies. So we would encourage you to document your wireless safe harbor carefully, just like you would for your do not call safe harbor, which we'll discuss briefly later. Possible exemptions to the new rules. Well, the wireless rules, prior express written consent. That's the big exemption that you should try and take advantage of. If you obtain and document the permission properly, you get to make auto-dialed telemarketing calls even to cell phones. Prior express consent doesn't have to be written for non-telemarketing calls and calls from tax-exempt nonprofits. And that rule did not change. Certain HIPAA-regulated healthcare messages. Calls to residential lines. Remember, you're exempt from the robocall ban to residential lines if you have consent, if it's for an emergency purpose, or if the calls are not telemarketing, either not for any commercial purpose, or even if they are for a commercial purpose, they don't include advertisements or telemarketing content. Also, calls made by or on behalf of a tax-exempt nonprofit organization are exempt from the landline pre-recorded ban, and again, certain HIPAA-related calls from a healthcare provider. How do you obtain the proper written consent to call cell phones? Let's talk about, let's read the rule quickly and then talk about some solutions and creative ways that you can get proper consent. Drafting consent language and disclosures is somewhat of an art. You can't just have one consent block that everybody uses in every situation. It's always different. The medium you're using to collect the consent matters. How are you getting it and where? And most importantly, how will you use that consent? Meaning, after you obtain consent, after you have this lead, this opt-in, how will you contact them? will be pre-recorded, SMS, email, live calls. I mean, that matters a lot. How you will contact them, the technology you will use, affects what you need to say in your consent language. So the FCC says that prior express written consent means an agreement in writing bearing the signature of the person called that clearly authorizes the seller to deliver or cause to be delivered to the person called advertisements or telemarketing messages using an automatic telephone dialing system or an artificial or pre-recorded voice, and the telephone number to which the signatory authorizes such advertisements or telemarketing messages to be delivered. The written agreement shall include a clear and conspicuous disclosure informing the person that, A, by executing the agreement, such person authorizes the seller to deliver or cause to be delivered to the signatory telemarketing calls using an ATDS or artificial or pre-recorded voice, and B, the person is not required to sign the agreement directly or indirectly or agree to enter into such an agreement as a condition of purchasing any property, goods, or services. Well, that's pretty convoluted. That's almost like reading, software code or something. It doesn't make a lot of sense. Let's try and break it down first
Eric,
this
before
way.
we do that,
yeah.
Can we go ahead and I think it'd be a good time to launch one of our polls, which was we wanted to know how companies are obtaining consent. So,
absolutely. Yeah, I'll let you run that.
A couple options for folks to vote on. You don't get to vote, Eric. But how are companies obtaining? Okay. How are companies obtaining consent with website capturing forms, oral, voice recording, or you have a big category there, other? I'll give people a couple seconds to answer, and we'll take a look at the answers in a minute. But yeah, there's lots of options. I mean, that's kind of something we hear is question: how do I get consent? How do I track it? I think we have enough votes in, so let's see. We got a couple seconds left on the. Give everybody a little bit of time here to finish up.
Yeah, I'm curious. There are a lot of ways of doing this, whether it's a website or a paper form, like a sweepstakes entry form or written contract or over the phone.
All right, we're going to close the poll, and then let's go ahead and share the results here. So number one was website capture. Second most was other. So we had a close race, voice recording and oral capture through representative. Pretty interesting.
Very interesting. I know a lot of, I know we field a lot of questions almost every day from online lead generators. So we've been representing call centers, but also vendors who service call centers and sellers, like dialer vendors and web lead generators. We're probably looking at proposed consent language and disclosures and processes and record-keeping techniques on a daily basis. And again, it varies by method. So you need a written agreement. You need a signature, but don't be alarmed because thankfully the FCC said in some commentary at the same time they published the rules. They said, you know what, when we said signature, we mean that to include an electronic signature, under the Federal e-Sign Act or any similar state law. And the agreement must indicate the specific seller or sellers. It's got to specify a telephone number. They have to take an affirmative action. It can't be just kind of a fuzzy, by interacting with us or participating in our program, you're agreeing. It has to be a very specific affirmative action to indicate the consent. And then you've got to disclose that the company is authorizing, or that the consumer is authorizing telemarketing calls to be made, meaning you've got to clarify the true marketing purpose of the call. I'm not saying you have to say the word telemarketing, but you have to make that clear. You have to clarify that the calls will be placed using an autodialer or pre-recorded SMS, whatever is applicable. And finally, you have to affirmatively tell them that the consumer is not required to consent as a condition of purchase, meaning you don't have to agree to receive our marketing calls in order to buy something from us. You get to buy even if you don't agree to receive our marketing. A lot of different options, websites, paper forms. Be careful, the FCC and FCC don't like sweepstakes entry forms. They're risky. You can't just hide the consent language on the fine print in the back, but you can do them compliant if you do them right. Let's look at some bad examples, real examples that we have seen over the last year. And if I told you where I saw these, these are some big brands. At least two of these you would know right away, kind of household name companies. I'm confident they've updated their consent language since I saw this. But the first one, by clicking below, you agree to be contacted by us and our affiliates about promotional offers. Not sufficient. It has virtually none of the required disclosures except that it makes clear it's a promotion. Next, and this is compliant but maybe a little impractical, kind of long. By clicking the submit button below, I expressly authorize Allen Legal to deliver or cause to be delivered telemarketing calls, pre-recorded messages, and SMS text messages regarding its products and services using an automatic telephone dialing system or an artificial or pre-recorded voice to me at the number I entered above, which I certify as my own number. I understand that I'm not required to give my consent as a condition of purchasing any property, goods, or services. That's pretty long, a little spooky, but it would certainly comply as long as it's in the right context and you have good record keeping and it was clear and conspicuous. What about this? Is this a good compromise? What do you think? By clicking the submit button below, I expressly authorize Allen Legal to contact me at my number I entered above about their services, including through the possible use of an autodialer, pre-recorded, and texts. I understand that I'm not required to consent in order to make a purchase, and I can opt out at any time. It's a bit softer. It's more concise. It's not that we cut corners here, but we try to consolidate some of the disclosures and just make it a little friendlier. I think in most settings this would be compliant. Again, if you do it right and you have the right record keeping and it's conspicuous enough and the way you use the leads in the future is consistent with the permission you obtained. And I'm sorry, here's those three bad examples. And again, a couple of these were from big brands about a year ago. I confirm that I have provided the correct and valid information agreed to be contacted by a company through any of the telephone numbers provided above or by any other manner deemed appropriate by a company for the purpose to follow up on my interest in the particular product stated above. Further, I agree that the company is not responsible for misuse of the information provided above unless it is proven that it's caused by company's willful misconduct or gross negligence. Very, very interesting, not compliant. Next, by selecting this box, I am agreeing to share my information with company and to receive future communications from company. Again, it's just missing a lot of those key disclosures. The nature of the messages. You have to indicate somehow that it's promotional, that they're offers, that it's marketing. It has to be a specific number. You got to tell them who's who's going to call and when, etc. By participating, I agree to receive important recordings and texts on my cell phone from company and its affiliates, even if I am on the do not call list. None of those are compliant for obvious reasons. Here's a shorter list, and if you're going to make your own little list on your sticky note there on your desk of what you have to have when you're obtaining proper TCPA consent to autodial a cell phone, this is it. Again, you don't need this exact level of consent for other purposes like debt collection, informational calls, and other things. But for telemarketing calls to a cell phone using an autodialer, or a text message or a pre-recorded message, for that matter, this is what you need. You need to identify the specific number to be called, meaning the consent is telephone number specific. You need to identify the true marketing purpose of the call, meaning you have to make clear that it's promotional. It can't be so generic that they could just assume it's for customer service only or debt collection and the like. 3, you have to identify the specific caller. Which business will call them? It can't be just generic. I agree to be contacted by anybody about a debt settlement or something. You have to tell them who they're giving permission to call them. There are some creative ways you can do that and get permission for multiple brands to call. We'll talk about that. So again, telephone number specific, purpose specific, caller specific. Next, technology specific. You have to tell them what technology you will use. For example, if applicable, you have to tell them you will use an automatic telephone dialing system, pre-recorded messages, text messages, etc. So it's technology specific. Next, you have to tell them they're not required to give that consent in order to buy from the company. Even if you never would require them to consent, you have to tell them that. It's not enough that you just not require it. You have to tell them specifically it's not required. Now, it's kind of silly because in some contexts that disclosure doesn't make sense, but this is right out of the statute. You have to tell them. You don't have prior express written consent to auto-dial the cell phone unless you told them when collecting consent that they're not required to give that consent in order to buy. Next, you have to collect an unambiguous each of these 5 examples, these are made up, and if one of these is the actual name of your company, I apologize. This is not your actual language I stole from your website or something. This is all made up. By clicking I agree, you agree to receive marketing calls and pre-recorded messages from student loan heroes using our automatic telephone dialing system at the number you entered above. Sounds great at first, doesn't it? Well, it's missing at least one key disclosure. One of those 6 things here. What is it missing? Think for just one moment. I've got the answers on the next slide, but let's move on. 2, by participating, you agree to receive auto-dial telemarketing calls, recordings, and text messages at your number above from solar energy saviors. You're not required to consent in order to obtain our services. What's it missing? When they say by participating, is that a clear, specific affirmative action? Really? Think about that. 3, by clicking go, you agree that educational consultants may call you or send you texts about important educational opportunities at the number / cell phone you entered above, and you understand you're not required to let us call or text you in order to enroll or purchase anything. What's it missing? Which of those kind of 6 key elements is it missing? 4, by clicking submit, you agree to be contacted about special vacation offers at the number you entered above using automated technology and pre-recorded messages. And you're not required to consent in order to purchase any vacation stay. It's missing at least one key disclosure. Finally, by clicking next screen, you agree that we at No Jokers Lending may call you using an automatic dialer and pre-recorded messages about short-term loan offers that may interest you. You are not required to consent in order to purchase. Okay, well, each of those is missing at least one key disclosure, and here they are. That first consent, set of consent language there is missing that kind of last disclosure that they're not required to consent in order to buy. That has to be in every TCPA consent block or consent process. You have to tell them that. Number 2, doesn't require a specific affirmative action evidencing consent. It can't be this kind of generic fuzzy by participating or by contacting us or by interacting with us or by purchasing from us. They have to take a special and, in my view, a single purpose action to evidence that consent. Number 3 doesn't tell them that you're going to call using automated technology. If you're going to use an ATDS, automatic telephone dialing system, and we'll talk about what that is later, but if you're going to do that, or if it's text or whatever, pre-recorded, you got to tell them. Number 4 doesn't inform the consenter which businesses they're giving permission to. Who's going to call them? Remember, the permission is caller specific. Finally, number 5 doesn't specify which number. The consent is telephone number specific as well. So be very careful. At first glance, a lot of consents just don't quite meet the new rigorous requirements. Now, you might be able to convince a judge that it was good enough, even if you're missing one of the disclosures. But there's also a very good chance you cannot, especially if the judge construes the language in the statute strictly, which happens. Okay, consent record keeping. How do you prove you had the right consent years later? Well, you need to store proof of the consent for at least 5 years. at least 5 years beyond the last date you're going to act in reliance on this consent. So it's not just 5 years. You've got to store it for 5 years beyond the last date that you're going to make a call relying on that consent. Now, normally you can only be sued under the TCPA by a consumer for up to 4 years, but we recommend 5 years. The FTC, for example, can bring an enforcement action for up to 5 years after the date of a violation. Okay, for web opt-ins, which again, according to our poll, I believe was the most popular way of capturing this TCPA opt-in to telemarket to a cell phone from a dialer. When you obtain that web opt-in, you need to capture and store. And again, these are best practices. In my view, you need to store the URL where the consent was obtained, time and date stamp, an IP address, and then this is the tricky one, either a screenshot or some other data or report showing what they saw when they consented and what they typed into the website form. That's the tough one. If you bring some piece of paper covered in HTML with a bunch of promises about what the consumer saw, that's going to be really hard for an old judge to understand. It's not going to make sense. You want to have a piece of paper that that your system can generate that looks like what the consumer saw, shows what they typed in, shows the disclosures, and then you want to, of course, tie to that this other information, URL, time and date, IP, etc. So consider how it would be in practice if you're actually trying to explain and prove to a regulator or a jury or a judge what proof you have for the consent. And assume the person you're trying to convince is not an expert at website marketing or website lead gen and complicated telemarketing processes. It's got to make sense. It's got to be simple and user-friendly. Some additional best practices to consider. Consider making them promise they own the number. There's this huge issue now about reassigned numbers and instances where maybe a spouse puts their husband's number in the consent form, or a friend, or, yeah, I know a buddy who would be interested in this. I'm just going to go ahead and put their number on this website. Well, person A normally cannot give permission for you to call person B. You need to get permission from that person. Make them promise it's their number. Make them think twice if they're putting in someone else's number. Remind them they can opt out at any time. That's a great thing to throw on the end of any little consent statement that instantly softens it. Oh yeah, no matter what all that legal mumbo-jumbo means, I can get out at any time. Consider adding that to the end of every consent. Consider using a dual or double opt-in, meaning if you get the consent on a website or on a recorded phone call, shoot them an informational confirmation text saying, we just received permission from you online to send you a telemarketing message. And if this is really you, and if you really did agree, reply yes or reply stop or opt out if not. Ask for consent at every consumer touch point. You really want to build up as big of an opt-in database as you can. You want to have a lot of callable numbers that you can dump in your autodialer, even if they're a cell phone. And remember that opt-in preference-based marketing is really the way of the future. Cold calling's tough and will not become any easier, I don't think. You can still do it if you are very careful, but it's burdensome. So don't try and just sneak in the consent or trick the consumer into giving consent. Make it front and center. You want them to remember they gave you consent so they don't make complaints or sue you. Win or lose, TCPA litigation is stressful and time-consuming and expensive. So you're trying not to tick people off. You want them to remember they consented. Finally, audit yourself frequently. If you're a compliance officer, do a random call log pull, find a few wireless numbers in there, go to your salespeople or your tech guys and say, hey guys, for these 3 calls, you've got an hour to prove to me with documents and a great explanation about how you had proper prior express written consent to call this number on an autodialer, given it's a cell phone. Prove that to me. And it better make sense and be simple, and they better be able to do it quickly and in a simple enough manner that you could explain it and convince an 80-year-old federal court judge who just doesn't know anything about telemarketing or websites or anything. Audit yourself. Let's think outside the box for yeah.
I was going to say this would be a good time before we jump to that next slide. We had a question came up. I've kind of heard this in other variations, but the way this one was phrased was fairly unique and applies to the section about consent, which is, can I bribe somebody, bribe is in quotes, someone to get consent, i.e. offer a premium if they give permission, no sale required?
You absolutely can. I'm trying to find my slide on this. You know what? Eventually we'll get to that slide. Oh, here it is. Yeah. So let's do this now then. Let's just jump ahead to this. Oh, this is the next slide. Okay.
That's pretty good.
Thank you, Scott.
That's a good transition.
Scott's sitting here with me. You know, my brother and I are on this really strict diet. We haven't been eating a whole lot, and we've been drinking too much coffee and not exercising. So we get a little spacey. Incentivizing consent. I think you can. I have heard a rumor from another law firm who says they were told by someone at the FCC that they would frown upon this. But the statute absolutely does not prevent it, and I've never seen anyone try and construe it to prohibit this. I think you can absolutely buy consent from the consumer. Here's an example that I thought of last night. As a valued Pizza King customer, we are offering you a limited time 50% off discount pizza coupon. By clicking the activation link below within the next 5 days to activate your discount card, you consent to receive auto-dialed text message offers from Pizza King at the number you entered above. You are not required to consent to our marketing in order to purchase, as you can always contact us directly to purchase pizza for standard pricing without allowing us to market to you. I think you can do this. That is, anyone who hires me will get that legal advice. Nothing in the TCPA says you cannot bribe them. The TCPA just says you cannot make it a condition of purchase, or you cannot, or rather, I misstated that, you cannot require the consent in order to allow them to purchase, meaning you still have to offer your products and services to people who don't agree to receive future marketing. But it doesn't say you can't bribe them. You can buy their consent. And I'm doubtful if the FCC really frowns upon it. I don't think they've really thought it through, or maybe they were put on the spot. I think that this is good for consumers. Why not be able to give them something, a premium, a prize, a discount, in exchange for their agreement to let you contact them? That's just a great idea and a great practice, I think, and should not be objectionable on any level. Again, they get to opt out later if they want to. They could get your coupon and opt out the first time they get a telemarketing call. They have that right. And finally, just because it was an element in my example, remember that truthful limited time offers are allowed as long as they do not create a false sense of urgency. You'll notice we had that, you got to do it within 5 days. Take advantage now. Don't think. Okay, thinking outside the box. Here's another example. Verbal recorded consent. Let's say you're obtaining, and let me just make sure, Scott, we didn't skip anything. Yeah, okay, you're right. Okay, so verbal recorded consent. Let's say you're fielding inbound calls from an infomercial or from a website or something. Or you otherwise are on the line with a consumer or an existing customer. You are able to obtain so-called written consent over the phone because of some comments the FCC made and because of the e-Sign Act. Consider this. Eric, one more thing. And again, this is on a live call. Eric, one more thing. There's never any obligation, but would it be all right for Allen Legal to call you in the future about our great legal services? Yeah? Wonderful. So just for compliance reasons, I'll need to read you this little statement here and then have you answer with a clear yes. Okay? To ensure you receive these great offers, you agree that Allen Legal may call you for marketing purposes using automated technology at the number you called us on today, which is your own number, and you understand that you're not required to consent to purchase and you can opt out at any time. And you agree that your recorded permission today will constitute should be your express written consent. Is that all correct? And if you get a yes and it's unambiguous and this is digitally recorded and you store it for at least 5 years beyond the date you rely on that consent, if you've got all that, that's sufficient. Why? Because in the FCC commentary, in the report and order, when they released the final, when they published the rules before they went into effect, but when they published them, they stated that written consent can be obtained through any process that complies with the e-Sign Act or any similar state law, including, and they said this specifically, word for word, including consent obtained during a recorded phone call. So we know it can be done. It would just be your obligation to do it properly and to have good record keeping. Now, what if they say no? Here's a tip on this. What if they say no or they have a concern? Be really careful. You don't want to accidentally explode your internal D&C, your own internal opt-out list. Train your agents to manage and overcome objections so that all of a sudden you don't go from having consent to talk to someone and then now you're asking for permission to auto-dial their cell or whatever, and then they say no, and you've got to put them on your do not call list. You don't want a no or a concern to be construed as a complete opt-out. But that will happen if you're not very careful and if your agent isn't trained to follow up and say, no, well, okay, just want to make sure we can still call you as long as we don't use our auto dialer and call your cell phone. Find out their preference. Find out, save as much of the consent as you can. Okay, what about avoiding the new auto dialer rules by using technology which is not an ATDS, automatic telephone dialing system? So to circumvent the rule, not circumvent, but to be exempt from the rule on the basis that you're not auto dialing, we got to know what an ATDS is. What's an ATDS, auto dialer? The FCC says that an auto dialer is equipment that has the capacity. Remember that word. That's a key element, capacity. Equipment which has the capacity to store or produce numbers to be called using a random or sequential number generator. Well, nobody does that. And to dial such numbers. Now, that's all the statute says. And if that were the end of it, none of us are auto-dialing. It used to be, when robocall first came to be, that this hardware would do random or sequential and just do voice broadcast or whatever. But modern auto dialers, like predictive dialers, don't do random or sequential. They dial from a list. So the FCC had to kind of change the rule and contradict what the statute actually says. Now, they shouldn't have done that. It's debatable whether they're even allowed to do that. There have been some courts who said, FCC, you can't do that. You can't contradict the plain meaning of the statute, which says to be an auto dialer has to do random or sequential generation and dialing. But nevertheless, the FCC did it. And you'll get sued if you ignore what the FCC has said when they interpreted their own rule and changed their own rule. So after the fact, they said that this definition covers any software which has the capacity to generate numbers and dial them without human intervention, regardless of whether the numbers are called randomly, sequentially, or come from calling lists. So they ignored the statute and they said what we really meant was, or what this really means is, any system that has the capacity to dial without human intervention in the initial or in the individual call initiations. And I need to speed up here, and I'm going to skip some of the content later on in our deck here so that we can finish with time for questions. Okay, so what does that mean? Well, there's these dialers now, manual dialers. Can there be such a thing, or is that an oxymoron? What about these preview dialers, click-to-call, preview mode, where all the software does is tee up the number. The agent sees the name and number to be called and clicks enter or a button on their phone or clicks the mouse to call that number. And they dial live, they hear ring, 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 they're on the call, they disposition it, and then do it all over again. Is that auto-dialing? Well, it depends on the capacity of the system. Remember, it's about capacity. You can't just switch your predictive dialer over into preview or one-on-one mode and say, I'm not auto-dialing. Well, it doesn't seem like you're auto-dialing, but according to the FCC, it's not about how you're dialing, really. It's about the capacity of the software. That's a dumb rule. There are a lot of petitions in trying to change that, but they're having no success. So a truly compliant preview dialer will have no capacity to do these other things, like random sequential. Really, it can only call numbers
by presenting the agent with the number and then forcing the agent to click to call the live number, one at a time with human intervention on each call initiation. And only certain preview platforms can do this. Again, they cannot have software code in them allowing for random sequential, predicted, pre-recorded, SMS, power dialing, multi-line, etc. If you have any of that auto dialer functionality, then there's a good chance your dialer will be considered to be an auto dialer by the FCC, by a plaintiff's attorney, by a judge. There's still a small risk
wasn't there a recent case on this where somebody used that as a defense, that they had separate dialer system and it seemed to work as far as
so whoever emails me afterward, I'll send him the case. But a couple weeks ago, we got some more clarification regarding current capacity versus future/theoretical capacity. There was a troubling case or two last year where a judge said, you know what, you could easily modify the software to auto dial, and therefore it does have auto dialer capacity. That's really dumb. You know, they focused on future theoretical capacity. But those decisions were very rare, and we got a great decision just, I want to say, a week or two ago where the judge said the opposite. No. It's about present capacity. What can the system do, not what could it do if you modified it. And there was also a good case on this last year where the judge basically said, you know, that's so silly. If we focus on future theoretical capacity, then every iPhone is an auto dialer because you could download an app that would allow you to auto dial, and that's dumb. Some tips. Be careful not to use a predictive platform that's branded as an auto dialer. Make sure it's branded in the advertising materials as being something different. Meaning, if you're going to say, look, we're going to buy this separate dialing platform that's totally separate, can't auto dialer, separate system, siloed off, not connected with our auto dialer system on any level. We're going to use it to call the cell phones, and we're going to dump the landlines in our normal predictive dial. If you're going to do that, awesome, but you need to be really careful, because a plaintiff's attorney trying to prove that it's an auto dialer still is going to look at the advertising materials for that product. What are the specs? Is it marketed as an auto dialer, or is it marketed as a manual line, as a TCPA kind of one-to-one compliant dialer? Be really careful. Also, two things if you're going to do this. Always get a letter from the developer, whether it's your software vendor or your own in-house developers, certifying the specs, meaning from a technical perspective, it could not predictively dial, even if told to do so. It could not do pre-recorded, even with all of its functionalities enabled. It can't do random sequential, even if told to do so, et cetera, et cetera, et cetera. Get that, take that to a lawyer, and get a legal opinion letter that your preview dialer is a manual dialer and not an auto dialer. If you have that, when you get the demand letter or lawsuit, you can shoot back your legal opinion letter and scare them off. They'll go look for someone else, some lower-hanging fruit. Okay, quickly. Again, thinking outside the box, new technologies, maybe some gray areas, maybe not. What do you think? This kind of direct to voicemail, direct drop type messaging. These are not calls per se. These are messages that show up on in your cell phone voicemail without causing your phone to ring. This circumvents the need to call the consumer's telephone number, but may still require a call to some carrier number. It also causes the MWA, the message waiting indicator. What do you think? Is that an auto dial call or not? Kind of a gray area. I want to say there's even a petition in the FCC. No response yet, but interesting. Also, this kind of pre-recorded snippet technology, this avatar stuff, and I may be being a little inaccurate in my wording here, but this is when you've got live agents, maybe they're in the Philippines, and they have heavy accents, but they want to communicate live with consumers in the U.S. So they call live, but they don't speak with their natural voice except in rare cases. They push buttons on their computer to play little pre-recorded snippets, messages recorded by American voice actors, and the consumer, the call recipient, usually can't even tell. It sounds like they're having a natural live conversation, which they are, except that the agent in the Philippines is pressing buttons on their computer to play pre-recorded words or phrases in order to interact. Well, what is that? Is that robocall or not? It's certainly not traditional robocall, but it does make use of pre-recorded messages. This is complicated by the fact that the live agent can often handle 2 or more calls at once and be listening live and interject with their live voice if they need to, but can press buttons to have essentially 2 or more conversations at once. That makes it look like auto dialing. But in my view, again, a lot of these technologies I think are compliant. They should be, but there's risk involved. There's risk because would a judge or jury or regulator agree with us? Maybe not. And again, litigation is costly, win or lose. This Bluetooth broadcasting stuff where someone's walking around on the Vegas Strip or something with a transmitter, it's sending out this invitation to view solicitation. It's transmitted to any Bluetooth-enabled device in range, your tablets, phones, car, PC, etc. The consumer gets to elect to receive or to view the message or decline. That's not really a call, but what if it's received by a cell phone? Could it be construed as a call, or does that get you around the rule? Consider some of these new technologies. I'm not saying they're a safe, compliant solution necessarily, but I think it's worth exploring, especially as we move forward, and we'll hopefully get some clarifications in the future on some of these. Social media messaging. Again, not a call, but what about these new apps? Like, what if the social media message is converted by an app into a text or vice versa? Watch out for these new platforms like Google Hangouts, etc. Will there be an intersection of social media kind of advertising compliance and telemarketing law? Maybe. Are landlines affected by the new rules? Well, not so much, although there's still a lot of rules about you not being able to deliver a pre-recorded message to a landline without consent. Also, some states are more restrictive. B2B, people think, B2B, nothing applies to me. I'm exempt from all this stuff. Not the case. These new cell phone rules are agnostic about the type of line, business versus consumer. They protect all cell phones, any telephone number assigned to a paging service or cellular telephone service, etc. So even if the FTC and FCC aren't really enforcing against B2B, you can absolutely and will get sued in a class action if you are predictably dialing business cell phones. Don't do it. Huge risk from private litigation. A lot of people want to say, well, I'm not really telemarketing. This is informational or it's just a survey. Be really, really, really careful. I'm not going to get deep into this, but the definitions are very, very broad. Even if your call in isolation doesn't sound like telemarketing, if it's part of a broader sales plan, it is telemarketing. Fines and penalties, very significant. Big government fines, injunctions, private right of action. Usually doesn't become criminal except if you start violating a court order or if there's a significant fraud component. No, it's not there. Telemarketingfines.com. Telemarketingfines.com. Our firm's put up a free 50-state chart on this. Here's the private right of action in the TCPA, which lets a consumer sue you for between $500 and $1,500 if you violate the rules. You know what, Ryan? I'm going to do a couple more TCPA suits. I'm going to skip most of the state stuff. It'll still be in the PowerPoint. But I think most people are on today to hear about the TCPA.
Yeah,
does that sound okay?
Yeah, let's do a quick final poll about if your company's been targeted by TCPA litigators.
Okay. Whether
directly or not at all, but maybe you know a colleague or somebody that's actually had the issues pop up. It'd be interesting to find out how folks are doing and what the consensus is. We'll give people a few seconds to answer that.
Okay, great. While they're doing that, Ryan, let me just point out that there's a bunch of other good slides in here with some tips for responding to TCPA lawsuits, or maybe it's just that you're subpoenaed. Maybe you're not the defendant, but you were the dialer vendor or the lead generator. I've got some good tips about what you should do right away to protect yourself and your company and your rights.
So we'll give people just a couple more seconds, and then we'll take a look at the results. So 20% said yes. So 1 out of 5 people have been targeted by TCPA litigators.
Wow, that's a huge number.
And then 20% know somebody that has.
Yeah. So for almost half of our folks on the webinar have either been named in the TCPA suit or know somebody who has.
It's pretty remarkable.
Very often it's the big brand that gets sued, and if you were just a dialer vendor or something, you normally don't get sued, but you still have got a lot of exposure because of indemnity agreements, and sometimes the vendors get named.
What's the typical cost of defending a TCPA lawsuit?
Oh, That varies greatly depending upon whether it's a class action or an individual suit, depending upon the scope. Is it just for one state or is it a national class action? It also depends on your legal counsel. If you're using some gigantic firm in downtown Manhattan, the cost is going to be different than if you're using a smaller kind of boutique firm like ours at a place like Salt Lake City. So there's a lot of factors, but it could range from maybe $10,000 to $50,000 or more a year while you're in litigation. I would say on the cheap side, you're going to be spending probably more than that, maybe $10,000 to $30,000 just in the first year at a bare minimum for TCPA litigation. Now, you hope you get the case resolved, in 6 or 9 months or something, but costs can stack up quite a bit. We represented and defended a dialer vendor for an ADT home security dealer in a huge class action last year. And I know for a fact that their legal fees just for 1 year in litigation were probably in the millions of dollars because they had ADT had a massive legal team working around the clock. They had a lot at stake. That's not going to be the same for a smaller brand that can be more efficient. So yeah, you're looking at tens of thousands, if not 6 figures per year while you're in litigation, just for the lawyers. And that's in addition to whatever judgment you end up having to pay or settlement. Very costly, so you want to avoid these things if you can. Ryan, let me just, were you done with that poll? Did we get all the?
Yeah, I got your slides
okay.
back up.
Okay, guys.
VoIP. Good numbers
there's this horrible case. There's this horrible case from last year, Monarch Recovery, where the court said, you know what? The way I read the rule, this covers VoIP because this guy was charged per call. So I'm going to treat a VoIP like a cell phone, and every VoIP number you called, you're on the hook for. That comes from this little catch-all kind of at the end of the ATDS definition. It's any telephone number assigned to a paging service, cellular telephone service, specialized mobile radio service, or other radio common carrier service, or any service for which the call party is charged for the call. Wow, that's pretty open-ended. I know, Ryan, your company, for example, has a new service to scrub out VoIP. And if you look here, these are updated stats from Ryan, thank you, as of yesterday. 1, 2, 3, 4, 5th bullet point down. There are a bunch of known VoIP prefixes now. If you want to be careful and scrub out VoIP, treat them like cell phones, I would recommend you do that until we get some clarification on this. Otherwise, you might be the next big VoIP class action, and we'll be talking about you next year. D&C stuff. Don't forget about rules like D&C, disclosures, licensing. TCPA is certainly the hot issue with the most exposure right now, but your call center can get in big trouble if you ignore the do not call lists. And my last little plug here will be for, again, what we call kind of the redheaded stepchild of telemarketing law. Often gets ignored, but companies are starting to get dinged for it more and more. You need to be licensed. Sellers, call centers, not just in your home state, but in states that you call into. There are a lot of states, roughly 33, that have some level of licensing. There are a lot of exemptions still, but you need to perform a careful analysis. We've had states like Arizona try and undo every deal a client did during the unlicensed period, meaning unilaterally go and issue refunds during the period they were not licensed. Be really careful. States like Florida will raid at gunpoint call centers on occasion for being unlicensed. Don't forget about some of these important state rules. We've got a free 50-state chart at telemarketinglicenses.com. My final tips for the day are these. Make compliance a priority in terms of budget and corporate philosophy. Establish your infrastructure early on and continue to update and audit. Have good record keeping. Half the battle is being compliant. The tougher part is being able to prove you're compliant 5 years later when you get sued. Resolve consumer complaints. A lot of this is complaint driven. If nobody's complaining about you, then most of the time nobody cares what you're doing. Be compliant, but don't tick people off. Resolve the complaints. Do your due diligence on the companies and vendors you work with. Have good contracts with your partners, and avoid regulatory pet projects like campaigns that target the elderly and financially distressed. Ryan, I think we're at about an hour now, but I'm happy to be on as long as you want to take questions if you have some good ones.
Yeah, we actually had quite a few good ones, and I appreciate the information provided today. I think there's a lot of good topics. We could probably go for another hour, but I'd like to wrap up with some real kind of practical tips. Well, a couple questions. I had people confused about the difference between B2B and B2C calls, and basically what you need to scrub on and for B2B versus some people now are even doing suppressions on the federal DNC list even for a B2B campaign. And maybe you could kind of just revisit that topic a little bit.
Absolutely, and we represent a lot of B2B only brands, so we get asked this a lot. So first, cell phones. In terms of the cell phone rules, the rules are the same if you're using an autodialer. So for example, if you're predictively dialing or delivering pre-recorded or text messages from an autodialer, then you cannot call that business number if it's a cell phone, just like you cannot call a consumer cell phone number without prior express written consent. Again, this is for telemarketing calls. If it's for informational or customer service or debt collection and you're sure of it, you're sure you haven't crossed the line, then the new rules don't apply. But for cell phones, business cell phones have the same protection as consumer cell phones. If you are predictively dialing for telemarketing purposes business cells right now without consent, you will have a class action within the next few months, or I'd be lucky if you survived another year. It will happen. These TCPA class actions and other suits are up by a huge margin over the last year, a year and a half since the rule change. Next, landlines. What about business landlines? You are still allowed, at least under the federal rules, to robocall. I'm talking voice broadcast, press 1 robocall business landlines under the federal rules. You cannot do that to consumer landlines. You cannot robocall consumer landlines without consent. You can robocall a genuine business landline without consent under the federal rules. Two things. There are a lot of states that are more strict. There are a lot of states that don't allow that. The state of Washington, for example. Washington State has a local robocall ban that applies also to business landlines. And there are a lot of state class actions for businesses who receive robocalls to their business landline up in Washington. A lot of states are like that. So be cautious. But under the federal rule, you can robocall business landlines. Second is, how do you know for sure it's a business number? Are you scraping domain registrant data from business-looking websites? Are you looking at business directories? Be very careful. Some of those could be dual-purpose lines or home-based businesses, or a line that they feel is their personal number and not primarily a business number. That's why I always recommend, not everyone will agree with me, but I strongly recommend, I think it's common sense and the best practice, that B2B call centers scrub consumer DNC even though they don't have to. Do it anyway. You can get a free SAN number, then you can hire Ryan's company, ding the consumer, the state and federal consumer do not call list, because you don't want to accidentally call consumer numbers. And almost all consumer numbers are on the federal or state DNC lists. So it's a great way to cut down on you accidentally calling a private residence that you thought was a business.
And you do actually have a lot of business numbers that have stuck to the federal list over the years. So definitely something where you'd be surprised how many numbers you match on. I've had campaigns run 40-50% drop rate when just scrubbing on the federal list that are technically a B2B campaign. And even the guy from the FTC said last year at the Pay Summit that those registrations should be honored, which was a surprise, even for B2B calls, as far as businesses.
Yeah, so that's alarming. I remember that comment. I was there. That's alarming because technically, reading the rules strictly, it's not a violation to call a business number, even if it was erroneously added to a consumer DNC list. But if the FCC is saying you should, and if you're running the risk of calling a number that you think it's a business number because it was held out as a business number at some point, but they think it's their private number, then you're going to get sued. And who knows? Are you going to be able to convince a judge that it was primarily a business number? Or are they going to convince a judge that it was primarily their private number? Also, watch out for states like Colorado where there's a Colorado State Supreme Court case a few years ago that said, you know what, we think our state D&C list protects home-based businesses. Next, Ryan, you got another question for us?
You dropped off there at the last maybe 20 seconds of whatever you just said.
Oh, I'm sorry. I was saying watch out for Colorado. Is a state where they've got a Supreme Court case that says that their state D&C list protects home-based businesses on that list. Can you hear me?
Yeah, so that's another good one to watch out, especially the state level. You do run into that. It's autodialer rule or state-specific rules, states that you can't manually call into on cell phones, just even without a dialer. Those are definitely.
Yeah, let me throw that slide up for anyone who wants to jot those 5 states down. These are states where the local cell phone rules is stricter. Remember, the federal rule only restricts auto-dialed calls to cells, but these 5 states restrict all telemarketing calls to cells, manual or auto-dialed. So be aware that some states go above and beyond the TCPA.
You've got some on the bottom there that I should probably know this because I'm in California, but the unsolicited SMS text messaging.
Correct. Yeah, some states have texting rules now, and there's a number of states that have proposed rules about texting right now as well. Bills in the works.
What about the federal level? Say you're running a text campaign, you still need consent, right, at the federal level to be able. You need to get an opt-in before you can run a text campaign, and then you got the problem of what kind of consent.
Yeah, the FCC and FTC have specifically said a text message is treated like a call for purposes of our rule. Now, if you manually punched out a text on your cell phone and sent it to someone, that's not a text from an ATDS. You might be okay. It's like a manual call, a manual text, but that's inefficient. Nobody does that. So, yeah, if you're texting using software, then you need the same consent you would need as if you were making a predictive call.
Good advice. What about HIPAA and TCPA? What's the impact? You had something on the slides about being exempt or HIPAA-related calls.
Yeah, so
they asked the question.
Yeah. Now, be really careful. This is a narrow exemption. This does not cover any health care or insurance-related call. It covers calls from a health care provider to a patient. And that's primarily, it's my understanding that the justification is, look, HIPAA already has rules for when a health care provider, like a doctor or a clinic, can market to its patients. There's already some level of relationship or consent required. So we're going to exempt from these new dialer rules rules that are of the certain flavor of HIPAA calls. Not all healthcare-related messages, and certainly not insurance marketing messages, but calls by or on behalf of a healthcare provider to their patient. If they are compliant with HIPAA, then they're going to be exempt from the new dialer rules. Now remember, they're just exempt from the new rules. There are still other rules that apply. They're not exempt from all telemarketing law, just from the new rule about needing written consent to auto-dial a cell phone. Email me later if you want. There's a couple good articles or white papers I can forward you on that specifically.
Here's a question on consent. Is affirmatively checking a box considered consent under the e-Sign Act?
It can be if you do it properly. If you use the right disclosures, if you have the right language, if it's clear and conspicuous, and if you record that consent properly, yes, a checked box works. What you can't just do is have a checkbox say, check this box to agree to our privacy policy, and then somewhere in the privacy policy you say, hey, by visiting our website, you get to we get to auto-dial you on your cell phone for the rest of your life. Can't do that. Can't hide it in the fine print. The privacy policy has to be clear and conspicuous immediately next to, the call to action, the button. I'd recommend you use an unchecked checkbox as well, or some other button. They have to express affirmative consent, an affirmative, purpose-specific action to indicate their consent. So yeah, you can have a checkbox. You can use that if you do it right.
What about the disclosure? Does it need to state that the person can opt out at any time?
No, it does not need to say that. I just recommend that as a best practice because I think it softens the disclosure. So no, the TCPA does not specifically require you to add that. Here, all that the TCPA requires are these 6 or so, I'll throw them back up for a minute here, elements here. Telephone number specific, purpose specific, caller specific, technology specific, and that they're not required to consent in order to buy. And then finally, you got to get that affirmative action.
I got a question, and this actually is one that I think confuses a lot of people. Is really the slide you had about the death of the EBR and the change in the EBR rules when it comes to the TCPA. And can you elaborate on the EBR exemption being deemed invalid? Does that only include predictive dialers, or is it only for robocalls?
Yeah, and people get confused by this a lot. Everybody freaked out when they heard that EBR was going away. Well, it's not gone away, not for the do not call lists. It's still an exemption to the do not call rules, even after the October 13 rule change. Meaning, for purposes of calling numbers on the do not call list, if you're trying to get around that rule specifically, the do not call list, then EBR saves you. Remember, 2 types of EBR. You get 18 months of EBR from a transaction and 3 months of EBR from an inquiry, meaning you get to call them even if they're on the DNC for a year and a half after they buy from you, or for 3 months after they make a product inquiry, even if they don't buy. But the dialer rules are totally separate from this. Don't confuse DNC rules with dialer and cell phone rules. Totally different. Doesn't matter whether a number's on the DNC list or not. If it's a cell phone, you cannot auto-dial it. And EBR is no longer an exemption. It used to be you can robocall the cell phones of your own client base. You cannot do that. EBR will let you manually dial them because it gets you around the DNC list. But to use an auto-dialer to call a cell phone, EBR doesn't give you a break. You need express written consent or one of the other exemptions we talked about. It is confusing. It's easy to confuse the two. People think, oh, an exemption's an exemption. Can I call them or not? It's not that simple because there are multiple layers of protection around the consumer, separate force fields. Once you pop the DNC bubble and move on, you still have to figure out how to get an exemption from these dialer rules. So separate rules, separate standards. EBR gets you around the DNC list, but not these new dialer cell phone rules.
Have you seen anything as far as the Mobile Marketing Association guideline for consent in terms of that as a resource, or are you familiar with those at all?
Yeah, and I'm probably not as familiar as I should be. I know their guidelines are pretty strict. They go beyond the rule. I want to say they're asking for a dual opt-in, which I did mention as a best practice. But beyond that, you probably better Google and pull up their new guidelines and read them yourself. I know they changed those guidelines very recently. So
we got a couple questions on best practices for verifying that the number that's provided upon consent continues to belong to that individual in terms of number verification and what people are actually doing to put in play to run that kind of verification.
Yeah, so you need to do some good hygiene on your data and also consider that dual opt-in. There is no easy solution to the reassigned number problem. There are big brands who have paid huge settlements on cases where, and this often comes up with debt collectors who they think they're calling person A. It turns out it's someone else. It was reassigned, or maybe they did a skip trace. Who is the called party for purposes of the TCPA? Is it the person you intended to call? No. Courts are starting to say pretty consistently, it's the person who owned the line, or sometimes the person who picked up the phone. That's dangerous. How do you know? How do you know whether the number was reassigned the day before you called them? How do you know that? Work with a vendor who does some data hygiene. Also consider a dual opt-in, meaning if you get, for example, if you get a website opt-in, you get a number from your website, You know, someone has given us this number and said we can call it, but do they really own that number? Send a confirmation text or email saying, is this really you? Do you own this number? Did you really give us permission to telemarket to you? Click this link or reply if you did so. And then do that periodically. You know, do it annually or quarterly or whatever. That will mitigate that risk.
I think we got most of the questions answered. Kind of try to group them together, kind of go back through the slides, which was a nice review. We are going to have the slides available for folks, so we'll send those out in an email. Also send a link to the recording from today's call so you can replay some of the information that we went through. Eric, I appreciate your insight today and giving people some really sound kind of best practices, good advice, kind of some more practical tips. I know there's been a lot of case law and this and that. I'd like to kind of take all of that and kind of put it in the blender and end up with something that you can actually work with. So.
Yeah, thank you, Ryan. It's been a pleasure. Guys, feel free to call Ryan or I or email us after this. You know, we do free consults. We'll do our best to give you some quick free push in the right direction. These slides and our advice today is not legal advice, of course. This is just meant to be informational, a push in the right direction, not guaranteed to be error-free, but we hope that it's been helpful to you. And here's our contact information.
As an additional resource, we can offer a free test on our litigator scrub solution for folks on the call. So if you want to get an idea of how many litigators maybe we can save you from hassle with later in the year, give us a call. We're happy to get something set up for you. Thank you, everyone.
Thanks, Ryan.
And have a great day.
Bye now.
Bye.